Welcome back to Floss Law. Major changes in the state of Illinois for wholesaling and real estate. We're going to talk about it right now, go over what you need to know, and what changes just happened. But first, if you're watching this on YouTube, if you could hit subscribe and like the video, it really helps with the algorithm for me to show up more. If you're watching this on Facebook, if you could also hit a like and then go to the page, if you can subscribe, follow along, and you can get all these videos when I'm updating it when they come out. Trying to do them a couple times a week now. Um, Wholesaling in Illinois. Wholesaling, if you don't know, is the act where you find a property, you put it under contract. So you, as the investor, real estate person, find a seller, you put a property under contract, you say you're going to buy it for X amount of money. You then turn around and you remarket that property to other people, other investors, other buyers, and you get them to buy the contract from you for hopefully, obviously, more money, and you make a little profit on that. So typically, the situation we find is a property that maybe was abandoned. The seller is embarrassed to put it on the market because of the condition of it, whatever it might be. Maybe it has a lot of bills on it, and the seller has just essentially left the property, abandoned it, they left the state, whatever. Someone finds that property, says, "Hey, I'll buy it for $100,000." They have it under contract. Now they can assign their contract. They can sell their contract over to someone else. Say someone else says they want to buy it for $110,000. They say, "Great, you make 10 grand." That's essentially the anatomy of a wholesale deal. You're connecting a buyer and a seller. You have a contractual right to the property. You're selling your contract. You're assigning your rights to that contract. Perfectly legal to do it. However, wholesaling was not something that was done very often. It was considered a business plan, or was it considered something that people would do very often? We would get them once in a while in the office, but it wasn't anything that was a big thing. I never really looked at it as something a real estate investor would want to do as a major real estate investment plan or strategy. That totally changed a few years ago. Wholesaling became wildly popular. We've seen wholesaling take a huge jump, particularly in the last few years, where people don't want to, say, pay the cost that would be involved with buying and flipping a property, with buying a property, paying for the closing costs to buy it, then turn around and have to pay the closing costs again to sell it. So a lot of investors started transitioning over to the idea of wholesaling, meaning connecting the buyer to the seller, only having to pay one set of closing costs and increasing their profits. As that became more popular, a lot more people started getting attracted to that because uh, the people a lot of times didn't have to be licensed to be involved with it, and it wasn't really governed. It was really, you were operating this huge gray area, and it got a lot of attention to a lot of different people because you could be a incredibly, I don't want to say, I was going to say low level, but I don't want to demean it like low level. Low entry point is what I'm trying to say. A low entry point real estate investor or person interested in real estate. You didn't have to go get your license. You didn't have to spend a bunch of money on education. You could do one webinar online, know pretty much the essentials of what you need to know to get into wholesaling, spend some money on advertising, doing mailers, and now you're a wholesaler. Um, so that attracted a lot of people. It attracted probably a few too many people. Also, whenever you're dealing with something with a low entry point that needs a minimal amount of effort and really education to get involved with it, it attracted a lot of the wrong type of people. So, the situation we're in now, real estate brokers and really most professional entities in the state of Illinois are subject to the Illinois Department of Financial and Professional Regulation. We're licensed by them, and as a part of that, your license is subject to regulation. If you do something wrong against the public, you harm the public, someone makes a complaint against you, you violate a portion of that act, they can go after you, they can fine you, they can take your license away and put you out of business if you're not the type of person that should be, conducting this type of business. You're not trustworthy. You're doing more harm than helping the public. They changed the act. So there's a lot of changes that were made to that act. We'll probably go through all of those changes at a later date, but right now I want to focus on this because I've been getting slammed with emails and calls in the last 48 hours with everyone losing their mind. Is wholesaling illegal now? Am I out of business? What's going to happen? Here's what really happened. They changed the definition of a broker in the state of Illinois under the Licensing Act. By changing the definition of what's a broker, they pulled wholesaling into it. So instead of just saying a broker is someone who lists and sells a house, whatever, the act now includes the definition of a broker as whether for another or for themselves, engages in a pattern of business of buying, selling, offering to buy or sell, marketing for sale, exchanging, or otherwise dealing in contracts, including assignable contracts for the purchase or sale or options in real estate or improvements thereof. For purposes of this definition, I'm quoting here, an individual or entity will be found to have engaged in a pattern of business if the individual or entity by itself or with any combination of other individuals or entities, we'll get to that in a minute, whether as partners or common owners in another entity, has engaged in one or more of these practices on 2 or more occasions in a 12-month period. So you get 2 freebies. Well, I'm sorry, you only get 1 freebie. If you do 2 or more, then you're in violation of the act. So if you do one wholesale deal a year, you're fine. If you do 2 or more, now you're subject to the act. Most wholesalers do a lot per year. So anyone that's involved seriously with wholesaling, this is going to hit them unless you just did one deal and decided to get out. So what does all that mean? Number one is, I have people panicking, did wholesaling become illegal? Wholesaling didn't become illegal. You can wholesale. Wholesale is perfectly legal. Remember at the beginning I said it's you have a contractual right. You can assign or sell that contract. That part's perfectly legal. You have to have a license to do it now, and the state has the right to say that you're providing the service to the public, same as your broker is licensed, the person who runs your nail salon is licensed, the person who does massages is licensed, your dentist is licensed. Everyone has a license, has a professional license, and this has become such a big part of real estate now that they felt that this is something that needs to be subject to license law. So now you can absolutely still wholesale, but you need to go get a broker's license in order to do wholesaling. Now, that sounds kind of easy on the surface. Just say, oh, go get a license. But that involves a lot of other things, and we're going to get to that. Just hang in there with me. There's a lot we got to cover here. One thing I want to cover right on the top is, I said I was going to come back to it, the part about being involved with any other entities, any other partners, any other common interest. I've already gotten a couple phone calls from people going, well, I can just do wholesaling, in one LLC, and then I can wholesale again with another guy doing a partnership, and then I can wholesale with another guy doing a different LLC. No, they're specifically saying you can't do that. You can't try to play a shell game where you do 10 wholesale deals a year and just play around with doing them in different entities. That's not going to work. It's in violation of the act. One person remarked, well, they have to catch me. We'll get to enforcement and them catching people in a second. But first I want to cover all the basics here in the beginning. So wholesaling is not illegal in Illinois. It's perfectly legal. But if you're going to do wholesaling, you need to have a broker's license. You need to stop, go enroll yourself in a class, and go get a broker's license if you're going to continue doing this. Everything else remains relatively the same, with exceptions of being subject now to a broker's license, which we're going to get to. So you have to be licensed. You're subject to all the laws that the brokers have to follow. And when you're a broker and you become a licensed broker, you have a duty to protect the public. Part of the reason that this is happening is there's a perception from the bad actors that are out there that they took advantage of sellers, that instead of saying your house is worth $250 and you put it on the market, they convinced them that the house is only worth $2, get it on the market, and then sell it to someone else for $250, and they pocket that $50,000 difference rather than the seller being told that it's worth $250. Now, many of you are going to post angry comments that that's not what you do. I understand. Some of you do some very hard work. You track down people who have abandoned properties. You have properties that are in very difficult situations. I do those closings. I understand. This doesn't affect you. This affects the bad actors. And now you're all being roped into, one category, and you're all going to have to go get your license. So I'm going to talk about the bad actors. Don't get all offended that you don't do it. I'm sure you're really good at what you do, but there's also some people that are really bad at this. So you're going to have to deal with that. I'm sorry. You're part of one group now. You're all going to have to go get licensed now because of it. So what are the bad actors doing? What the bad actors are doing is sending out what's termed as like a yellow letter. So a yellow letter is designed to look like it's a handwritten note, but it's really printed out on a mass printer. So they'll print out 1,000 of a mailer that looks like it was handwritten on like a legal paper. And they mail those out and they say, oh, I want to, my wife and I really like this area and we want to buy a house here. Please give us a call. Well, you call the number and they say, yeah, I really like this neighborhood. I want to buy this house. Can I come take a look at it? They come take a look at it. They say, well, I can offer you, 200,000 for this property and I can close right away. So you enter into a purchase contract. That's where and I warned people about this a few months back. I forget if I did this on a blog or on a video. Some of the states, the attorney generals were looking at this portion of the process that they didn't like the purchase contract because they felt it was bad faith that you're putting a purchase contract that says that you in good faith, one of the clauses in there is typically that you're going to operate in good faith, that you're going to buy this property. But you weren't operating in good faith, you're operating in bad faith because you had no intention of ever purchasing that property. If you didn't find another person to buy it from you, you had no intention of following through with closing on it. I think it was Washington, there was a West Coast state that was looking at that as being something that they maybe thought violated the law, that if you're entering into a purchase contract, if you're not actually able to purchase it, then that shouldn't be a valid contract and you're taking advantage of that person. So there's that standpoint of it. I usually coached my clients that did this, that I never really liked the idea of them using a purchase contract, that you should have full disclosure and use an assignment contract. It's a separate contract that specifically says that I'm entering into the ability to purchase this property, that I will assign at a later date, or I guess I should say an option contract. You're putting an option on the property. Hey, I'm going to pay $200,000 for this property, or I have the ability to option to purchase this property for $200,000 for the next 60 days. If I don't exercise that option, then you can sell it to whoever else you want. But I have the option to buy for the next 60 days, and I'm going to try to find someone else to sell this property to. I'm always a big believer of disclosing everything up front, so the seller knows exactly what you're doing, what you're interested in as the property, and what your plan is. So the other people are entering into this purchase contract and letting the seller to believe that they're going to buy it, but they're not going to buy it. What they do is they turn around then, they create an offering package, offering memorandum. They have pictures of the property. They say how much they're going to buy the property for, what their estimated amount of repairs are, and then what their comps of what they think the property will be worth after you've done the repairs. Typically, these are for rehab properties. You'll very rarely see it for just like a regular owner occupied. It's usually a property that needs a rehab done to it. So they'll have the rehab costs in there. They'll have the estimate of what they believe it'll be worth after the rehab, what you can sell it for, and they're trying to sell this contract off to you, sell this property off to you. That part also was on the radar for a lot of different states of if that was unlicensed broker activity because you're advertising the property for sale. Now, the counter argument where the State Department's kind of got caught in a gray area was if they have the property under contract and they're now have an executed contract where they have an ownership interest in the property. They haven't closed yet, but they're under contract. So they have an ownership interest that they're not doing brokerage activities because they're trying to advertise a property that they in some way own. So it's not a brokerage activity. So it was sort of that argument going back and forth where it created this gray area of, well, some people felt they were violating the act of doing unlicensed advertising of a property for sale, and they would come back and say, well, I own the property, or I have a right to the property, so I get to advertise, my properties for sale, just like a FSBO would. So they get caught in that area. So part of doing this was to close that loophole as well. Excuse me. So then you get to the point of now you have to actually do the closing. And this, me as the attorney, where I would encounter problems because I want everything to be disclosed. I want everything to be upfront with everyone. And a lot of times I would get two different scenarios. Not with the people that I would represent, but with when I would be walking with a buyer, with an investor at closing, we would walk into the closing room, and one of two things: either the wholesaler would be trying to figure out a way of not getting paid on the HUD because they either didn't want, or both, didn't want the buyer to know how much they were getting, how much, the difference of what they are selling it to the buyer for and what they have it under contract for. And they don't want the seller to know how much they're getting for their assignment fee, after the buyer's paying for the property, what their profit is. They don't want the buyer to know. They don't want the seller to know, which is a huge problem. I mean, you're violating RESPA. If you're getting paid, it needs to be on the settlement statement. It needs to be on that HUD at closing. So if you're trying to hide that, there's something seriously wrong. The other situation I would see a lot is they essentially would not tell anyone until you're sitting down at their closing table what all the money is that's exchanging hands. So what I mean by that is essentially they would put together the settlement statement, put it in front of everybody, and at that moment would be the first time that the buyer would know how much the wholesaler is making, and the first time the seller would know how much the wholesaler was making. And it would create a massive amount of confusion and sometimes anger at the table. And the wholesaler would be taking the gamble that they wouldn't be angry enough to walk from the deal. Because remember, they have the property under contract, so they can't just walk away and separate them from the deal. They have a contractual right to the property, so the title can't clear them off. They have a right to it. So you have the option of either closing or just walking away from the deal. And more times than not, usually the buyer, whoever the investor was, would just go, you're making a lot more than I thought you were making, whatever, and move on and want to close on it. Who would really be angry sometimes would be those sellers, because it would be the first time it would really be hitting the seller that this wholesaler is walking away with a 30 grand check, and if they would have just put the property on the MLS, they could have gotten that much more money for it. So there would be a lot of unhappiness, and when I'm sitting there with my buyer, an incredibly uncomfortable situation. I've been in a closing room where there's a term called a daisy chain. A daisy chain is when you have multiple wholesalers on the same deal. So I had a deal. I don't remember the exact number, so I'm guesstimating here a little bit. But it was a vacant lot for putting a new construction home on a very up-and-coming neighborhood, a very nice neighborhood. And we basically found out the day before closing that it was there was multiple wholesalers. We knew that we were getting it from a wholesale. We didn't find out till right before that we were getting it from a double wholesale deal, a daisy chain. Obviously, my buyer still wanted the property. He didn't care whatever the situation was. But as we were walking into the closing room, and you had the seller sitting there who's getting $250,000 for the house. You had the wholesaler who had sold it to the other wholesaler for $300,000 and was getting a $50,000 check. You had the second wholesaler that was selling it to my client for $350,000, give or take, and was also getting a $50,000 check. So you had a seller sitting there realizing for the first time that their lot was worth $100,000 more than what they were getting at the closing table. That was a very unhappy person. Basically, you're at the closing table. I don't remember many details about the seller because this was a couple years ago. They did end up just signing the closing documents and going along with it. At that point, they just wanted their money and to walk away. But that was a very unhappy person, and I bet they walked away feeling really dumb that they essentially walked away from $100,000 of equity in this property that my client bought. That's an example of the public discourse, the public anger that has come out with wholesalers, and I believe why this is happening. Because right now there really isn't anything that's governing wholesalers. So the Licensing Act is essentially grabbing wholesalers and saying, okay, you're under our roof now. We're going to tell you guys what you can and can't do from here on out, because we're not going to continue doing what you're doing right now. So that's essentially explaining wholesaling the best I can, and there's a lot more involved with that. The good wholesalers that I work with do a lot of good work for properties that have delinquent taxes, have horrific water bills in the city of Chicago. The sellers don't know what to do with the property. Maybe the property would go for $10,000 on the MLS because there's the way the wholesalers market is, you're paying $10,000 for it, but you also have for the property, but you need to pay for the $30,000 of unpaid bills that are on it. It would be really hard to market those on the MLS. Now we're going to have to going forward, essentially, but that was a lot of the scenarios that we'd be dealing with. Properties where essentially the seller just didn't know what to do with it anymore, and needed someone else to essentially come in and handle that. Now, the view of the licensing department is great. If you're in that bad of a scenario, you can have a educated licensed professional help you with that, not a person who just has their own company that we don't have any ability to kind of look at what they're doing and make sure that they're handling it correctly. So I don't disagree with that. I absolutely understand what they're trying to accomplish here, and I don't disagree, because there are some people that got horribly taken advantage of with this. Also, I mean, just get your license. I don't really see how it's this huge deal. I have people acting like it's the on-road to the apocalypse. I mean, it's just go get your license. I mean, it's not the end of the world. I do have an opinion that some people purposefully did this or took this avenue because they either have something in their past where they would not be able to get a license, which kind of sets off a red flag, or they know what they're doing, or the behavior that they have. If they were subject to a license, they would get penalized for it. So they were purposefully doing wholesaling because they knew there was nothing governing it, and they were operating in this gray area because they didn't want to be subject to a review board or a licensing board or anything like that. I think that some of that comes into play with this too, that people are angry that now they're subject to government review of what they're doing, and they didn't want that, or they're worried about what's going to happen now. So if you do 2 or more wholesales now, you'll be subject to unlicensed practice of real estate, which carries a heavy monetary fine. I've seen some really big talk online that, good luck finding me, or good luck, enforcing it, or whatever. You don't want to get on the bad side of the licensing department. Don't play that game. Full disclosure, when I was in law school, I clerked for IDFPR. I did the real estate complaints. I helped with the real estate complaints. I was a law clerk, so I did a fair amount of work, but I was working underneath an attorney. And I've seen some very questionable comments from people both on Facebook and some on LinkedIn and some of the other websites about this, saying that there's going to be a task force, and there probably will be a task force, but it's not like there's going to be, the IDFPR, SWAT team's going to come in and come get you guys. The reality is the majority of complaints from IDFPR or that IDFPR initiates come from either members of the public or other licensed professionals. And I told this to a couple people yesterday, because they're asking me, how is this going to be regulated? Do they have the resources to go after us? What's going to happen? And I said, look, the reality is the people who are going to file the complaints with IDFPR against the wholesalers come down to one of 3 categories. Number 1 is sellers that are upset. So like those people that said at the closing they were upset about what happened, they're going to file complaints once they hear about this. 2, realtors, because some realtors just absolutely hate wholesalers. There's just no other way of saying it, so they're going to file complaints. And 3, if people who are professional wholesalers that are licensed already my guess are going to be the ones that are going to initiate the most complaints because they're going to eliminate all of their competition. Wholesaling is extremely competitive because so many people have entered have entered that area because it is such a low level entry point. You basically just have to take a webinar, spend the money on doing some mailers, and you're in business. The licensed wholesalers are going to be picking off their competition. Any mailers, anything that go out, they're going to be filing it immediately with IDFPR, and you better believe they're going to be taking out as many people out of their business as they can because, like I said, it is extremely competitive, and the more people they can get out of the picture, the better it's going to be for them and the higher return on their marketing. So my expectation is IDFPR is going to get flooded with complaints from licensed wholesalers trying to push other people out of the business to make it better for them. So although wholesalers out there that are unlicensed, it's probably going to be the people who you have met with and probably people that you think that you're friendly with at networking events that you've talked to in the past that are licensed that are probably going to push you out, or they're going to make you cut a deal with them to continue doing business going forward using their broker's license. That's kind of the reality of the situation. So now that you're a broker, doing wholesaling, what's going to happen? Essentially, all that has to change is the fact that you're now a licensed broker. In reality, now that you're required to be a licensed broker as a wholesaler, there are a bunch of other things that get pulled in with it. It's not just you get a broker's license and it's done. There's a lot of other things that go along with that now that you're going to have to kind of figure out how to change your business model. One being, obviously, when you're a broker, there's a lot of expectations as far as what your advertising has to be. So you have to, whenever you're doing any kind of activity in real estate, there's an expectation that you have to disclose that you are a licensed professional, you are a licensed agent. When you are negotiating with those sellers to continue doing wholesaling going forward, you have an expectation you need to disclose to them, oh, hey, I'm a licensed agent, because they're not a professional, you are, and you need to tell them that so they have that expectation. Turning around when you're selling that property, even if you don't intend on listing it, you're just going to continue doing what a lot of them do now, which is develop an email list of investors that they know, and they email it to all their investors and see if anyone's interested in it. Or you have like Facebook groups and things like that. If you're going to continue doing that, you're going to be subject to the advertising requirements of you as a broker. So you don't have to necessarily list it with your managing broker, although your individual managing broker may have different rules. So you're going to have to be subject to whatever your office rules are, that you have to list your property, or whatever the case may be, or you can't list your own property, or you can't do dual agency in your own office or anything like that. It's possible that your managing broker, if you're going to wholesale, will not allow you to be the only broker on the deal. They may say you have to assign another broker in our office to represent that seller, and then you can represent yourself as the buyer to limit our liability in our office because we don't trust you that you're not going to expose us to liability. Same thing on the sales side. They may say when you turn around and sell it, even if you're doing the wholesale activity and you're emailing it to your investor list, you have to disclose that you are a broker, that you're a broker with our office, where our office is located, put our branding on there, doing all of that. And additionally, you can't do dual agency because it's your property. Now, you can't, if you're selling your own property, you can't do dual agency. So hopefully this isn't news to you, but some of the wholesalers are not necessarily up to speed with this. There's going to be a learning curve. So expect when you're changing your business model, you're going to go get your license. You're going to represent yourself as the seller, but you can't represent that buyer. So you're going to have to include other agents. You're going to have to pay other commissions on these deals. So it's not going to be as simple as you put it under contract and you get your check at closing. You're going to have to include other people with this. You're going to have to do some team building. You have to do networking. You're going to have to work with other people. And again, you're going to be subject to whatever rules your managing broker has. I've heard of offices where the managing broker, to limit their liability, won't allow you to list your own property. You have to co-list it with someone else because you can't be responsible for listing your own property. So there's a lot of things that are going to limit what you can do depending on where you do put your license. You're subject to those office rules as well. So continuing on, you're going to be subject to those advertising rules. You're subject to, you have a duty to protect the public as a broker. Part of being a licensed broker is becoming educated that you have a duty to the public. That's where I see a lot of the wholesalers and the realtors really get into fights with each other, because the realtors that take the ethics very seriously are offended that if you know the property is worth 250 and you're putting under contract for two, that you are really damaging the public, that you're hurting that seller. It should just go on the market for 250. And why are you allowed to take advantage of that person? You're violating, the duty, the ethics that a lot of agents feel that they have to the public, to get them the highest and best value for their property, not what you can get it for so you can make a profit. There's a lot of fighting with that we have to deal with. And now that you're going to be a licensed broker going forward, you're going to have to get educated on those ethics and really make a decision as far as, when you're wholesaling going forward, where do you feel that you lie on the issue of these ethics, and how, at one point, are you allowed to negotiate a deal where you can make a profit versus when you're negotiating a deal where you might be taking advantage of someone. And that's subjective. That's a deal by deal basis. There's some deals where the seller needs a lot of help and they're happy to pay you so you can get them out of a bad situation with taxes, water bill, whatever. And there's some situations where people are just convincing the seller that it's worth less when it's really worth a lot more, like the scenario I told you about a few years back. So it's a case-by-case basis. It's going to be very difficult going forward, and there's going to have to be a lot of changes in business plans for wholesaling businesses going forward because of this. I believe the state is going to really be looking at this stuff hard and looking at real estate activity hard going forward. Now, there are some really good advantages depending on, again, your office, depending on which board you belong to, depending on, the MLS's viewpoint of it. I have talked to some people who said that they were able to maybe find an absentee owner, place the property under contract, and then using their contractual rights, place it on the MLS so they could get just a fair market buyer for the property. The seller knew what was going on. There was full disclosure, and they said the deal went great. So there is more of an opportunity instead of sort of this hustling where you're getting a property under contract and you put it on Facebook and you do kind of like a weird blind ad on Craigslist, and then you send it out to whatever email list you have. Now that you're a licensed broker, you can work something out where you could just put the property on the MLS and get it for sale. I kind of fall somewhere in the middle of that. I know, again, the agents will come back and say, well, why don't you just list it then? The wholesalers will come back, and I saw this scenario this morning. Someone brought up, you could make a couple $100s on a commission if the property is only worth 25 grand because it's a bad property. But if I say a wholesaler, I put it in a contract for 25, or I put in a contract for 20, and if I find a buyer for 25, now I made $5,000 for it. Now it's a little bit worth my time for the effort I need to do to put a buyer on that property. I can kind of see where they're coming from with that. I don't quite know how I feel about that one as far as moving forward now that everyone has to be licensed. But we're going to see. It's going to take time to kind of really analyze how this is going to affect everyone's business moving forward, and our business practices moving forward. So I talked about you're subject to broker regulations. You have to disclose your office. You have a duty to protect the public. Disclosure. You have to disclose everything. The major thing in broker activity and being a licensed broker is just disclosure. You have a duty to disclose everything, or the best business practice is to disclose everything. There's always a bad actor with everything. Certainly there are bad brokers too. I'm not going to deny that. But going forward, you have to disclose everything. You should never, ever have a scenario where you go into the closing table and the seller is completely blindsided by how much the wholesaler, is making. We can't have those situations anymore. And I believe that that's why this is happening. This is why you're subject to licensing now. We talked about the purchase contract issue if you're entering in bad faith. Are you hiding the details? Are you trying to violate RESPA by trying to somehow get paid off the HUD? My 100% of the time, my answer to that is no. And did you take advantage of the seller? So that's essentially what's going on with wholesaling right now. If you have questions or comments, please comment below. Let me know. You can always reach out to me directly. In summary, going forward, if you are wholesaling in Illinois, if you plan on doing more than one wholesale, you do need to go get your broker's license. You need to get licensed. You could still do wholesaling. It's perfectly legal as long as you have a license. So if you're a licensed wholesaler, pretty much nothing has to change for you. This doesn't affect you at all. If you're unlicensed, you need to go get yourself into a licensing class right away, pronto. Oh, I should point out it is effective immediately. So this isn't one of those things where it's effective January 1st and you get an opportunity to kind of wrap up your business. They didn't do that here. This is something where it went effective at the moment that it was signed into law. This is effective as of right now. So if you've already done a wholesale deal this year, you're out of business until you get your license. So you need to go get in there right away. There's classes everywhere. You can contact your local board. You can find them online. You can do whatever you want to do. There's tons of real estate schools out there that you can contact. Go get your license. You'll be better for it. You'll be more educated. You'll know more about the business, and you'll be in a better situation moving forward to make better decisions. And really, people who get involved with wholesaling say that they do it because they want to get involved with real estate. Well, now you've gotten a push that you need to be more involved with real estate, at least as far as getting your license. And it'll make you better. It'll be better for the public. It'll be better for everyone in the long run. At least I believe that. I've had a broker's license for a long time, very long time. I obviously am more of an attorney now, but I believe having a background, having a broker's license is better for you understanding how to be involved with real estate, your relationship with the public, and what you can and can't do. A lot of wholesalers, unfortunately, don't understand what they're allowed to say or not say, do or not do, misleading advertising, kind of bait and switch advertising, blind ads. And that was one of the other changes that was made in the Licensing Act. We'll deal with that when I do the complete licensing update. But they made some changes to the way you do blind ads. They want to make sure that as the wholesalers are moving forward, that when you are advertising the property, you are advertising it under your broker's license, under your brokerage, and then you're not advertising at the seller of the property. You need to act as an agent now. You need to advertise that. I believe that's it. If you have questions, please contact me. Let me know. I'll probably do another update video on this maybe later this week, early next week, because there's still a lot we got to pull out of here. But that's it for right now. Have a good one.